Good afternoon. Welcome to our meeting where we are going to be discussing school resource officers and discussing their logistics, what they are, and how might they be used in our school in the future. For those of you who do not know me, I'm Principal Daly, and I am here to discuss not just the laws, but also our reasoning for school resource officers. And so first, we're going to discuss what is the purpose of a school resource officer. And one thing that we need to be aware of, this quote comes directly from the mission statement of the Illinois Police. We will relentlessly protect public safety and pursue justice for the people of Illinois. So if you were to, I got that straight from their mission and vision page on their website. And one thing that we need to be very clear about is that all resource officers are sworn in law enforcement employees. And what makes a school resource officer important to a school is that they have three main jobs that they're to perform. They are obviously, first is law enforcement, but then there are also law-related counselors and law-related educators. And so in Illinois, there are specific requirements that people have to pass in order to get this certificate. So one of the first things with these requirements is that all officers are required to take a 40-hour training, and this 40-hour training covers juvenile law, officer and youth interactions, and school threat responses. In order to be eligible to be a school resource officer, they have to be a full-time employee as an officer. They've had to have been a full-time employed officer for at least 3 years. They must have sound character, free of any disciplinary concerns, and most importantly, they need to be open to working with minors, as they will be in schools every day of the school year. Now, in order to complete their courses, they need to attend 90% of the classes in person. They can only miss due to an excused absence. They need to complete the conclusionary exam/assessment, and then those assessments and exams are reviewed, and then if they pass those, then they are allowed to get their certificate. Now, for this 40-hour course, I found all this information on the Illinois State Police Board website. And so as I looked through their courses, those main three key pieces, you had your juvenile law, your officer and youth interactions, and your school threat response. And so under the juvenile law, they have to take a class that starts with Intro to Juvenile Law, which makes sense, but then also due process for juveniles, the detention of juveniles, and remember, with detention with police, this means detaining. So not that our SROs can give detentions, but this is a lawful detention due to either threat of harm to self or to others. And then interviewing witnesses and their rights of parents. For officer and youth interactions, they have to take a class that goes through the development of the adolescent brain. So they need to be knowledgeable about what are these students able to do at what age. This is really important as kids don't fully understand certain law requirements, and as an officer, they need to act in a way that is reasonable to what the children are able to cognitively do. Then they need to go over what their roles are as an SRO. They need to review the school structure and hierarchy. They also need to go over student communication, and they take diversity classing with developing relationships with diverse students. So with that diversity, it's not just talking about race and ethnicity, but as we go to that next one, understanding special needs that youth considerations and disabilities have as well. So they need to properly trained for students who both have no 504s or IEPs, but they also need to be able to interact with students who do have disabilities. And then for the school threat response, they need to be trained in criminal activity in schools. So what are the most common issues that they are to see? And then the lawful actions that they can take to enforce those laws in schools. They need to go over the ethical concerns. They will go over school safety and design. They also will practice tactical maneuvering on school grounds. They will be trained in post-event situations, and then specific threat response scenarios. Altogether, this will be 40 hours, and again, they need to complete 90% of it in person, and the only way they can miss is if it's an excused absence. If they are to randomly miss, then they have to restart the whole process. And so the goal of this training is to produce officers who are knowledgeable about not only the law, but positive relationship building and how to respond to school-related events and tragedies. One thing that I want to keep us in mind with this is they are officers, they are trained, and 91% of all current SROs are armed while they're at the school. And we will come back to this when we discuss SROs in our school district. Now, there are some significant court cases that we need to address involving what powers SROs have in schools. And so first we're going to start that investigation in Shade versus City of Farmington in 2002. It was deemed that searches are reasonable when involving weapons. In this specific case, students were being bused to an off-school technical program, and they stopped for breakfast. One person got a juice box, he couldn't open it, and when he asked someone if they had something, and they were back on the bus, a different student gave him a foldable knife. He used the knife to open up the juice box. The teacher saw the knife in the rearview mirror in the bus who was driving, and called over the SROs to search. Now, the student that he saw did not have a knife on him, so then they searched the other students. And in this court case, it was found reasonable that involving weapons for safety, that these police officers could search without a warrant. And that is for off-campus. Now in Washington versus Manise in 2012, the Washington Supreme Court ruled that SROs are not school officials for purposes of on-campus searches. And so in this case, students were searched. The students sued claiming that as school officials, they didn't have the right to do that. But since they are state employed officials, Washington did rule that they are not school officials in the capacity when they start investigating and doing searches. From there, we have Pitcha versus Wilgos in 1976, and this states that students have a constitutional right not to be searched by school officials who were in contact with the police unless the extent of the intrusion occasioned by the search was justified in terms of the state interest of maintaining the order, discipline, safety, supervision, and education of the students within the school. Whew, that was a mouthful. So basically, students cannot just be searched off of a whim. The only time that students can be searched by SROs is if it is in the state's interest of maintaining either order in the classroom or the school, for discipline and disciplinary reasons, safety, as was discussed with Shade versus City of Farmington, overall supervision, and making sure that the school is able to educate. And so most citizens, you do need a warrant before you can be searched. However, in schools, as long as it is reasonable for those specific reasons, then SROs can search. Next, police officers and SROs, they are able to detain, whether that's handcuffs, whether that is being able to take a student and put them away from other students. And so in CB versus City of Sonora in 2014, in this one, an 11-year-old with disabilities was found to be unlawfully detained as it was excessive when he was locked in a car for 30 minutes. The student was not being compliant. The student was initially a danger to themselves and to others, and so the police officer handcuffed this child, which they found was lawful, but then they kept him in a car for 30 minutes, and that's where they said that is unreasonable. So as SROs, they are able to detain, but it needs to be reasonable within what is going on. So for example, in EC versus City of Suffolk, it was found that it was not unreasonable to handcuff a student for 5 minutes to prevent them from biting and hitting others. So the SRO there was able to use handcuffs to detain because it was in the interest of people's safety. In JBD versus North Carolina in 2011, now we're going to be switching on over to interrogations. And so in this case, the overall ruling was that persons subjected to custodial interrogations must be read their Miranda rights. Now, with these interrogations for these children, we also need to remember that not all children have the capacity to understand that they're being interrogated. And so SR officers are not able to always interrogate every student. There needs to be a reasonable assumption that the student has the mental capacity to understand that they're being interrogated. And so for this one, the SRO officer, the SRO did not read the student their Miranda rights. And because of that, they sued that he did not properly inform, and they were correct. Now, along those lines, in NC versus Kentucky in 2012, if a school leader interrogates a student and the Miranda rights are not read by the SRO, then the evidence can be suppressed. Students are still American citizens and they are protected under state law and for federal rights, and one of those is those Miranda rights of knowing that they don't need to say anything unless a lawyer is present, as well as unless they are being specifically warranted for some kind of behavior, they also can leave whenever they want for this. And so if a student offers up evidence that they did do a certain activity but were not informed of their Miranda rights, then in the case that evidence can be suppressed based on the fact that the child did not know what they were allowed to and not to do. While we're talking about investigating, especially in schools where safety of students involving drugs is a unfortunate issue that needs to be addressed. Um, while we talk about searches uh, by police officers themselves and how those can be lawful, many times these SROs will use dogs. And so in Horton versus Goose Creek Independent School District in 1982, an alert from a drug sniffing dog gives a reasonable cause to search a student's car. Now, there have been many different types of cases, or many different cases involving dogs, and specifically drug sniffing dogs. And so, going on to Wisconsin versus Van Beek in 2009, um, or quick, going back to Horton, in some states where these cases have been brought up, it's been found that a dog cannot sniff the person, as that would take away their dignity, but dogs can sniff items that are not on person. So that would be lockers, that would be cars, that could be backpacks if they're not being worn by the student. And the state does need to prove that the dog is a certified drug sniffing dog in order for that to be a reasonable cause. However, interestingly enough, the state does not need to prove that the dog is itself a high performing drug sniffing capabilities. So that's where knowing these laws is going to be very important. And then if students are incorrectly detained or disciplined, when we look at Wisconsin versus Van Beek, if students say that they weren't, but they were found to be, then they can be charged for restitute damages. So for what they caused. And in Wisconsin versus Van Beek, this scenario, a student had called in a bomb threat to the school, and due to the school shutting down for the day and people losing their pay, the district sued the student for those damages. And then going back, with Carey versus Pifus in 1978, if students are disciplined incorrectly, especially by the SROs, then they can receive nominal damages, but these are not to exceed $1. And now we're going to talk about our school and why we use security guards instead of SRO officers, or SROs. So, for our reasoning, SROs are only allowed when the district and community have written contracts with the police agencies. And for us, our school board has yet to approve such an agreement. And so because our school board and school have deemed it not necessary, we have not gone down that path yet. Now, there are some pros and cons to this. One of the pros of using security guards over SROs is that many claim that it promotes a more positive climate. We are aware of the school to prison pipeline, where if students have behavioral issues in school, they're more likely to then have issues with law enforcement as adults. And one thing that is a problem with having police in schools is that this can be a risk of over-policing. Areas where there are a lot of police officers are going to have a lot of reported crime because there are more police officers there to report it. Thus, the areas that are less policed will usually have less police reports because there are less police there to report them. And so the idea here is that instead of using law enforcement as a main foundation of appropriate behavior, the goal with our security guards is to build more relationships with the students and have them understand what is appropriate behavior and without the risk of law enforcement and unlawful disciplines. Another important thing to think about is that statistic where 91% of SROs are armed with guns. It is important that our students are safe. And these security guards are not trained officers. They do not have guns. And so there are less risk of guns just being in the school and less risk of gun violence happening in general. Now, there are some cons to having security guards instead of SROs. One is that there is a lack of adolescent training. I have discussed and talked with many of the security guards at our school about their training to be a security guard, and I asked them if they had to do anything special in order to be certified to work in a school, and they said no. And so I asked them if they had any training about either relationship building or working with students, and again, they said no. So we have these adults who are usually working at concert venues, as one stated, or in businesses where they're dealing mainly with adults, and then they come to a school and they don't know how to work with kids. Many of them are parents, and so they have kids, but it's completely different when it is in a school situation. They've not been taught the school hierarchy, and so this lack of training can result in the securities not only being ineffective, but also developing those negative relationships, which defeats the purpose of the pro. Another issue with these security guards is they are not school staff in the sense that teachers are. And they have no authority, meaning these security officers, they can tell kids what to do, but the students know they don't have to listen. And the only time that there are consequences, them not listening, is if a teacher is nearby, and then the teacher has the authority to write referrals for the student's behavior. Because the students know that the security guards cannot write them up for either defiance, disrespect, disruption, then the students who are already going to have behavior issues, it led to them that they're able to just do what they want. The students who are already going to do the right thing, being told by a security officer, is going to do the right thing regardless. So that lack of authority makes them ineffective with those students who need those consequences. And so because of this, we then have inconsistent procedures. We have some adults who have the authority to write up students for those behaviors that they should not be exhibiting, but at the same time, we have adults who cannot. And this lends to, therefore, the security guards not being able to fully do their job into the capacity that they should, and it requires a lot more help from the teachers. And so I'm going to leave this question with you. Our district has decided to not use SROs, and so if you were in charge of your school, would you want to use SROs? And if so, why? I hope that this enlightened you about SROs. I did not know what an SRO was, as in my district we have never had them. So learning about them was helpful to know that the security guard or that these officers are able to have training to make them effective. And for me personally, I can see why SROs would be utilized in schools, especially with this training. My issue is as law enforcement and over policing, especially in areas that already have demographics that do not have good relationships with police. Depending on who those SROs are, if they are not fully aware of those demographics and how the history of police have affected those community relations, they can do more harm than good. And so for me personally, I'm glad that we use security guards, but clearly there are procedures, policies that need to be put in place to give them more authority so that they themselves can do the jobs that they are hired to do. So thank you for your time, and I look forward to hearing, would you use SROs in your school? Have a great day. Bye.